The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Thank you for attending today's webinar. And on behalf of the National Council of Juvenile and Family Court Judges, the National Congress of American Indians, and the Tribal Law and Policy Institute, I'd like to welcome you to today's webinar, Enforcing Protection Orders Generally, and also for the Special Domestic Violence Criminal Jurisdiction over non-Indians under the VAWA. Today, Virginia Davis will be moderating the questions she's from NCAI, and that will be at the end of today's webinar. And I'd like to introduce myself, Chia Halpern-Vitsla with the Tribal Law and Policy Institute. Today's presenters are the Honorable Stephen Aycock, Judge in Residence at the National Council of Juvenile and Family Court Judges, as well as the Honorable Kelly Gaines Stoner, Victim Advocacy Legal Specialist from the Tribal Law and Policy Institute, and she is also a judge at the Seminole Nation of Oklahoma. Today's presentation will be about 30 minutes, and then we'll have time for question and answer at the end. So if you have any questions, please type them into the panel here on the right-hand side of your screen. There should be a section for questions about third from the bottom. You can also raise your hand too towards the end. Today's webinar slides will be emailed out to you all within 24 hours, and we will also have a recording available on the Tribal Law and Policy Institute website, and I will also email everybody with the link as well. And with that, I would like to turn it over to Kelly and Steve.
Thank you, Chia. Again, this is Kelly Stoner with the Tribal Law and Policy Institute. I'm also a judge for the Seminole Nation of Oklahoma, and I have the honor of co-presenting with Steve Aycock today. Would you like to say a few words, Steve, to introduce yourself?
Sure. Hi, everybody. This is Steve Aycock. I'm the Judge in Residence at the National Council of Juvenile and Family Court Judges, and I worked with the Colville Confederated Tribes for 21 years, the first 12 years running their legal services office, and the last 9 years as their chief judge.
So, great. It's great to have a lot of experience on the panel today. Let's go over the learning objectives really quickly, and I wanted to just reiterate what Chia just mentioned, that this is the second in a series of 3 protection order webinars that are being put on. And if you missed the last webinar, I believe Chia said you can get it on the TLPI website or the NCAI website. So we are building off of that first webinar, but we're going to do a little bit of a review here at the beginning to get everybody on the same page. So we're going to once again quickly go over the VAWA 2013 Full Faith and Credit required language for protection orders, because today's webinar is really going to be focusing on how do you enforce, how do you get these, if there's a violation of a protection order, what types of enforcement can we use in tribal court, and we'll talk more maybe about state court at the end. So we're going to be pointing out, and hopefully you're going to be absorbing some important civil and criminal jurisdictional issues that are related to enforcing protection orders in tribal court, and we're going to talk about the difference between civil and criminal remedies for protection order violations. I'll point out that today we're not going into great detail about civil and criminal contempt as a mechanism for enforcing a protection order, because that's the entire focus of next week's webinar. So if we can move to the next slide. And I want to remind everybody in the audience, well, I should probably back up a little bit and use my manners and welcome you all for being here. This is something that both Judge Aycock and myself feel is just an incredibly important topic. And to start off with just kind of remembering the purpose of a protection order, because it serves a multi-purpose, and we really want to ensure that in that protection order language there are clear commands of the court. You're going to find those commands, sometimes we call it remedies, and it's the court putting restrictions, parameters, if you will, on the behaviors of the perpetrator. It's always, or should always, be issued with victim safety in mind. That's the whole purpose of the protection order, is to put parameters on the perpetrator's behavior so that that it will enhance victim safety. And it's another message sort of to the perpetrator is that the behavior has become so inappropriate and dangerous that the court has to step in and tell this perpetrator or batterer what behaviors are now going to be acceptable. So in doing that, it takes the court, the order itself is taking some power and control away from the batterer, which also may have an effect on victim safety. And I'm hoping that everyone would have a victim advocate working with them in this kind of situation, because tribal victim advocates are truly specialists in honing in on that victim safety piece. And the very last benefit of a protection order is really what we're going to be talking about today. It's holding batterers accountable. It's setting forth these commands from the court that are to enhance victim safety, and there are repercussions, there are consequences if those commands of the court are violated. So when we think about full faith and credit, which is really critical to getting your protection order enforced across the board, across the United States, across jurisdictional boundaries. And there are some requirements in VAWA 2013. We went over these last week, but again, I just wanted to touch on them here. Subject matter jurisdiction, which gets a little bit tricky in tribal court, so we'll revisit that issue very briefly, not as in depth as we did last week. Personal jurisdiction, you have jurisdiction over the parties, the tribal court does, that the perpetrator or the batterer has been given notice of what's happening in tribal court and an opportunity to be heard, to give their side of the story. If there is an ex parte order, that's an order before both parties are presenting testimony or evidence to the court, that ex parte order will be followed up within a certain number of days according to the tribal court or the tribal code or the applicable code. There's going to be a full hearing there. And also that the protection order has not expired. Obviously, if a protection order is expired, it's not entitled to full faith and credit. So we're thinking about all of those things, kind of just getting everyone on the same page before we delve into the enforcement of protection order issues. And this is such a critical issue for tribes. And again, we'll talk possibly towards the end of the presentation about what happens when you cross jurisdictional boundaries from tribe to state. But we know that protection orders for tribes, it's directly tied to a tribe's sovereign power. And it's a power that goes directly towards being able, the tribal government being able to keep citizens safe. So in order to do that, we are going to be thinking about utilizing creative civil remedies over non-member Indians and non-Indians in the civil realm. We're going to, a way to maximize that power is to also use TLOA, or the Tribal Law and Order Act, to loosen federal restrictions on tribal court sentencing authority for those tribes that can meet TLOA mandates. We'll go over those very quickly. And we also want to use tribal criminal codes to hold Indian violators of protection orders accountable, and utilize special domestic violence criminal jurisdiction to hold non-Indian offenders accountable. So remember, both TLOA and special domestic violence criminal jurisdiction are going to have some earmarks that the tribe is going to have to meet before the tribe can loosen those restrictions and once again begin to exercise those enhanced powers. So we're going to be using some words here that I wanted to make sure that we all are on the same page with. Again, civil contempt is going to be a very important piece of the enforcement mechanism. That's going to be a focus of the webinar next week, as will criminal contempt. So those are typically the vehicles by which a protection order violation will be enforced. And there are some other means that we'll talk about as we move through this protection order as well. Judge Aycock, did you want to talk about jurisdiction?
Sure. I just think it's important to understand what federal law says around the tribe's jurisdiction. For those who are living in Indian country, and that's defined in Section 1151 of the U.S. Code, and what it's really saying is that if it arises anywhere in your Indian country or otherwise within the authority of the tribe, then you have the power to issue and enforce protections involving any person. It doesn't matter whether they are Indian, non-Indian, non-member Indian. It may limit what you can do, but for instance, for civil contempt, you have the, as this says, you have the ability to enforce any orders through civil contempt proceedings. So it doesn't matter who these people are. If they're committing these violations within your Indian country, then you can go ahead and exercise jurisdiction. I'm going to turn this back over to you, Judge Stone.
Okay, and so I will talk about, and we're talking about subject matter jurisdiction here, against the civil component to that. And we know that with respect to non-member Indians, or non-members we should just say, which includes non-Indians, the Supreme Court of the United States has put some restrictions on tribal civil jurisdiction. And so we've been given a test, the Montana test. We also spoke about this last week, but I just wanted to have this up here so that you could kind of look back and remind yourself what the two prongs of the Montana test are. And this test, this Montana test, is going to apply anytime you have non-members on fee land within a reservation or fee land within your Indian country, arguably. And this is not, you know, there are maybe some exceptions to this, but this is the rule we're going to be using today. So anytime you have a civil case in front of you, which includes a protection order, and it involves non-members, whether they're Indian or non-Indian, and fee land, the tribal court really needs to take evidence and make a finding that it's met one or both of the Montana tests. And here they are, A and B, that the parties have entered into a consensual relationship with the tribe or its members, and this is kind of a shortened version of it. But you can argue, you know, if there's a couple in front of you, they have an intimate relationship, that they have entered into a consensual relationship, and one of those people is a tribal member perhaps, or that the domestic violence that brought these parties in front of the court today has some direct effect on the political integrity, economic security, health, or welfare of the tribe. And given the national statistics about domestic violence and Native American women, I think it's fairly easy to meet that test. But again, you need to take some evidence and make some judicial findings that you've met the Montana test. And again, that's assuming that your tribal code allows you to do that. We're going to go with that assumption throughout the whole presentation. So I get ahead of myself, and I apologize. Again, it's really sort of a best practice, I think. I don't know if you agree with me, Judge Aycock, but I think it is when you have this fact pattern in front of you, a protection order involving a non-member, that it's really a sort of a gold standard for the judge to find that whether each party is a member of the tribe or a member of a federally recognized tribe or a non-Indian. And again, we want to make sure that language makes its way into the order and that there's enough testimony that the judge can make a finding that if Montana applies, that it's been met. One of the prongs, anyway.
And I have a slight disagreement, because I do think that the section that we just read on slide 8, I believe, about jurisdiction, there it is, that answers the question if it's in the Indian country of the tribe or otherwise within the authority. Now, certainly you could make an argument that this somehow did not override Montana. So I do think it's best practice for the judge to at least, even if they don't go through the whole Montana analysis, at the very least to say why it is the court thinks it has jurisdiction over this particular non-member. And it seems to me that you could say things like they're in an intimate relationship, or they have a child together, or he lives on the reservation, or this person lives off the reservation but comes onto the reservation for X, Y, and Z purposes on a regular basis. I mean, some connection, I think, beyond just the fact of the act occurring on the reservation would be helpful. But I think there's an argument that this section overrides Montana.
I do think, I don't know that I disagree with you at all, but I do think that it's important that the tribe, each tribe has defined its Indian country, because what is Indian country for one tribe may be very different for another. And I think that's why we end up with those, arises within Indian country or is otherwise within the jurisdiction of the tribe or within the power or authority of the tribe. So
yes, I agree. So moving on here, so it's important to remember, right, that every tribe can be, or every jurisdiction can be both an enforcing and an issuing jurisdiction. So what are the parameters of what you can do? So as the issuing court, right, so you issue orders and you should issue clear orders to facilitate enforcement, particularly when they go to other jurisdictions, but it also is helpful, of course, within your own jurisdiction. And enforcing. So this applies to both law enforcement and courts. The statute specifically says that law enforcement and courts of a foreign jurisdiction shall enforce your protection orders as if they were the protection orders issued in their own jurisdiction. So the court determines whether the order was violated, okay? And you look to the issuing jurisdiction at that point. But they use the enforcing state process and punishment for violations. And if we can go to the next one, let me give you some examples. So if your order says that, or let's say you have a foreign order, and your statute says that you can issue a protection order for no more than 1 year, and you get a protection order from a jurisdiction that allows up to 5 years, and it says right on the face of the protection order that this order is valid for a period of 5 years. If we're into year 3 or 4, you, as the enforcing court, would enforce it as it was written, not by what your law says. Also, as to whom it protects, and the terms and conditions of the order would end up being treated the same way. So that's this idea of the substance. So the substance of the order is enforced as it is written. So what about the enforcing jurisdiction? What do they determine? So if the order says that this order can only be, and again it's a foreign order, it can only be enforced through criminal contempt, but your tribe does not have criminal contempt. It has a crime or it has civil contempt. It doesn't matter what that said on the order. You get to use your own procedures and how it's enforced. And same thing with the penalties and sanctions. So if the order says the maximum penalty for violation of this order is 90 days, but your code allows punishment up to 180 days, then it's your code that you would use to make those determinations of what the penalties and sanctions should be for the violation.
And when we talk about why might you choose a civil enforcement mechanism over a criminal enforcement mechanism for a violation of a protection order, there's a difference. A civil enforcement is basically a lower burden of proof. It's by a preponderance of the evidence, which is about 51%. It's much, much easier to prove in a civil court a violation of a protection order than it is through the criminal court via a criminal contempt, which is going to require beyond a reasonable doubt. Also, when we're talking about due process requirements, the civil due process requirements, which might be the same or maybe a little bit different, a little more relaxed in the civil court, as opposed to the process that you're giving, the due process you're giving this criminal defendant, that also is another issue. So I think, we want you to know that you have a couple of options here, and you can do both, I think, as well. You can utilize both of them. Okay, when we talk about some creative civil remedies, what can you do if you haven't quite gotten to, the tribe quite hasn't gotten to the point where, or has decided it's not going to exercise special domestic violence criminal jurisdiction over non-Indians, which we're going to be talking about in just a few minutes. Can you still hold the non-Indian violator accountable for a violation of a protection order in Indian country? And you can, utilizing civil remedies, and here are some examples. You can use fines, attorney's fees and costs, restitution, forfeiture, exclusion, which I know is one that many tribes use, and then again civil contempt of court, which we'll talk about next week. Civil commitment is up here. I don't know very many tribes that utilize that, and that is where you basically have put an individual, a batterer, in a secure facility because that person is going to be a danger to the community, and this has just an enormous cost that goes along with it, but we wanted to list it just as well. And civil arrest, although you have to be careful that you're not using these civil mechanisms in the criminal realm. If we're talking about custom and tradition, that again is going to look very, very different for each tribe. Some examples: providing deer meat to a family or extended family. These are civil remedies that could be enforced. You're requiring some sort of act on behalf of the batterer to comply with the order. Providing firewood, ditch digging, paying for ceremonies or bringing items to ceremonies, shaming, which interestingly enough has been upheld by the U.S. Supreme Court. Whatever that looked like in your tribal court historically, those are some types of civil remedies that you can use. Other tribal civil regulatory remedies: removing the name of the batterer from the tribal lease. Now these will be governed by tribal code, so these are just some general examples. Restricting of access of the batterer's access to tribal benefits if the batterer does have some tribal benefits. Restricting access to business licenses, and you can kind of look down through here for some other ideas on creative civil remedies.
Let me just say that a few years back now, the Southwest Center on Law and Policy held a roundtable and issued a report afterwards that lays out a lot of these creative civil remedies, and it's available on their website.
Thank you. I happen to be a co-author on that one, I'll just say. Yes, and that was that's where a lot of those civil remedies came from, was from that round table. So the power to enforce a tribal protection over an Indian violator is a much easier question than the non-Indian violator. And we know that the Supreme Court has held that tribes have criminal jurisdiction over all Indians who commit crimes in their Indian country. But again, we would be looking to the enforcement jurisdiction's tribal code if this case has moved, the protection order has been, kind of the victim has moved on into a different Indian country and there's been a violation, then that particular jurisdiction would be looking at their tribal code. Would you like to go over this slide, Judge Aycock?
Sure. So VAWA 2013 added some language that specifically recognized the tribe's inherent criminal jurisdiction over non-Indians who commit certain acts in certain places against certain people. And we'll get into what those requirements are in a minute. But I think it's important to recognize that this was not a delegation of congressional power or authority to the tribes. This was a recognition of their inherent sovereign authority. And the reason that's important is two-level. One is just anytime we can get Congress to recognize the inherent authority of tribes and their sovereignty, that's a great thing in Indian country. The second part is that it means that if it's a serious offense, you could charge somebody in tribal court and convict them there, and they could also then be convicted in federal court, and it would not be a double jeopardy problem. So what gets covered? Well, so it has to occur, again, in the Indian country of the tribe. It has to violate a portion of the protection order that meets the VAWA full faith and credit requirements. And those are those portions of the protection order that prohibit these kinds of acts. So violent, threatening acts, harassment, sexual violence, contact, communication, physical proximity. Okay? So it does not cover failure to pay child support. It does not cover other kinds of financial relief. So we just talked a little bit about maybe deer meat or wood. Those things probably are not would not be covered under this because it's not one of these listed things that's actually in the statute. And it's important to recognize that for you to be a victim under VAWA 2013 for purposes of a protection order violation, and it's a non-Indian who's doing the violation, that a victim then has to be specifically set out in the protection order. So rather than saying Jane Doe and her children, you need to say Jane Doe and Billy Joe and whoever else the children's names are. So that if in case he assaults one of the children, that is then covered and that person would be a victim. So, and there would be an argument if you just said Jane Doe and her children. Maybe they are protected, maybe they're not protected. The best practice, again, is to make sure that you list everyone specifically by name and any kind of identifier, like a birth date or something, so you can actually identify who that person is later when you're trying to get it enforced. And then it's important to recognize that because of that, because you can protect people broader than the normal criminal domestic violence jurisdiction under VAWA 2013, so child abuse, elder abuse, sexual assault, even between two strangers, can in fact be enforced as a violation of a protection order. But remember, the victim has to be specifically protected by that protection order. So what other requirements? So it has to be issued against the defendant, obviously. It has to be enforceable by the participating tribe. So this is where you would look to your constitution and your codes to make sure that you can, in fact, enforce against non-Indians. And then it has to be consistent with this section of Title 18. And it's, does the next, I can't remember, does the next slide, no, so the next, so those are what we talked about last week, which is essentially that you have subject matter jurisdiction, personal jurisdiction, that there was an opportunity, a notice and opportunity to be heard, and it's still in effect. That's what makes it consistent with 2256B.
And although that wasn't labeled, we went over that early on in the PowerPoint, so you do have that slide with you. Let's go over what VAWA 2013 Section 904, again, special domestic violence criminal jurisdiction, does not cover. If both the victim and the defendant are non-Indian, it does not, this will not cover that, Section 904. In order to cover for the tribe to have special domestic violence criminal jurisdiction over the non-Indian defendant who violates a protection order in Indian country, the court or the prosecutor has to establish beyond a reasonable doubt that the defendant resides in the Indian country of the participating tribe, or is employed in the Indian country of the participating tribe, or that the defendant is a spouse, intimate partner, or dating partner of a tribal member or an Indian who resides in the Indian country of the participating tribe. Important to note that the spouse, intimate partner, dating partner, that does not have to be the victim. These are jurisdictional sort of contacts that have to be established before Section 904 can be applied to a non-Indian in Indian country. Also, if the crime does not take place in the Indian country of a participating tribe, Section 904 will not apply. And those lines get a little bit blurred with respect to contact and various other issues, and it's extremely important for the tribes to actually define what is their Indian country. And again, that may be easier for a reservation-based tribe, not maybe so easy for the Oklahoma tribes that talk about their service areas, which arguably are their reservation boundaries or former reservation boundaries. And also, it's important to note that 904 does not apply if the tribe chooses not to meet the requirements of VAWA 2013 Section 904. So this is optional for a tribe, and only tribes that can meet the requirements of Section 904 are going to be able to exercise this type of criminal jurisdiction over non-Indians for violation of protection orders in Indian country. And we just wanted to kind of, this chart we've seen and we use it a lot in our trainings, and we're going to just, I don't even know if we're going to go through it since we're running short on time, but just so you have it, it lists the requirements of the Tribal Law and Order Act, which again enhances tribal court criminal sentencing authority, and it also lists Section 904 VAWA Special Domestic Violence Criminal Jurisdiction requirements, many of which are the same. There are some distinct differences, but as we go through the slides and those little check marks appear and disappear, you can kind of see that if you comply with one, you're getting very close usually to complying with Section 904. There is a distinction with the jury and the cross-section of a jury pool and the right to habeas. There are some distinctions.
Before we open it up for questions, I just want to say that as we were on the phone before we started the presentation today, we got to talking about enforcement across state and tribe boundaries and jurisdictions. And it's important to remember that the federal law says that if the protection order meets these requirements that we set up, this 2256B requirements, the jurisdiction, notice, those things, that full faith and credit shall apply. So courts shall apply and give full faith and credit to foreign jurisdictions orders that meet those requirements. And that applies to both states and tribes. For states in particular, if they're not doing that, there are some remedies. The most obvious ones probably are just doing an appeal or some sort of mandamus to make them comply with federal law. But there's also, they could lose some or all of their VAWA money if they're not doing that. So they could lose their STOP grant, for instance, which for most states is a big pot of money, and nobody sort of wants to lose that money. So I think there are some things you could do, but it's also important to remember that that applies to tribes as well. And we recognize that there are places where tribes, for historical reasons, may not want to grant full faith and credit to state court orders. But it is important also to recognize that it is the state of federal law, and the same thing could happen that I just talked to you about with state courts, although I'm not sure that you could lose your STOP money, but you could get sued for failure to comply with federal law. Anything you wanted to say on that, Judge Stoner or Virginia?
Nothing for me. Thanks for covering that.
I just wanted to point out that and underscore what Judge Aycock said. I mean, that is the status of federal law, and whether or not it's occurring is another issue. But there are some mechanisms that you can be using if you're, again, now we have to remember, you have to have a protection order that complies with VAWA 2013 full faith and credit. So that was last week's webinar, which we went over how carefully you have to draft these protection orders, and if it's a tribal protection order involving non-members, how we think that the jurisdictional piece that's put in the order should probably not be a check-the-box kind of piece. It stresses again how important the remedies are, that they're clearly written so that indeed the judge can make a finding, civil or criminal, that there was a violation of a protection order. Because I have seen protection orders come across my desk that are maybe 2 paragraphs long, and they don't comply with VAWA full faith and credit. And the remedies are written so broadly, I don't know how anyone could prove if it was the remedy had been violated. So in that instance, that victim has a false sense of reliance on that order because it's most likely not going to be enforced. So we did want to put, I'm going to back up one more second because I think this is so important too, especially because I do a lot of practice in Oklahoma, where you know, what is and is not Indian country is continually changing. And I think it's critical for tribes to decide what their Indian country is, even if it's very narrowly decided for purposes of civil enforcement, and you can have a separate what is Indian country for purposes of criminal enforcement. Some tribes it'll be the same, some tribes can have a different definition of Indian country for each of those. So it's important to do that. So because all of these issues are really, the jurisdictional pieces are tied back to Indian country. And that really does need to be defined. So when we're talking about resources, I just want to go through just a couple of these with you before we hit the next slide. We've given you some tribal jurisdictional charts. You've probably seen those before. There is a website, it's tribalprotectionorder.com, I believe. That might be a typo there. If you're wanting to get more information about confidentiality for tribal victims, we've given you a live link there, some victims' rights information, and some VAWA 2013 information. There's just a whole host of resources on the NCAI website and the TLPI website on how to draft your codes, to comply with TLOA and VAWA, how to set up a domestic violence court. So we've really tried to provide a very resource-rich environment on these websites to be tailored to use as your tribal communities require. This is just a screenshot of the tribal court website, the TLPI website, and just a whole host of resources there. This is the NCAI website. They have a whole section on VAWA, as you can see there, lots of resources. This is the tribalprotectionorder.org. In the resource slide, I believe there's a typo there. So this is the way you tap into this resource, and it will take you to some tips for drafting protection orders, for enforcing protection orders. It'll go into the firearms language that has to be in the protection order, as well as listing some resources.
And this is one of our publications at the National Council. It's meant for judges in both tribal and state courts, and it's basically some bench cards. There's a bench card there's two bench cards on full faith and credit, one for the issuing court, one for the enforcing court. There's two bench cards on child custody and visitation and support that's in a foreign protection order, and then there are two bench cards on firearms and domestic violence issues. Also, if you go here and you go up back to publications, you will also then find our guide on civil protection orders as well. Again, which is meant for a broad audience, it's not specific to Indian country.
Chia, or Virginia, do you want to see if we have any questions?
Great, yeah, if you all, in your dashboard that's showing up, you should be able to either type in the question or click the button to raise your hand. And if you raise your hand, we will unmute you and we can have a discussion.
And while we're waiting for that, I think I'll ask Judge Aycock a question. Judge Aycock, what would your advice be if I am a tribal victim advocate? I've got a victim with a tribal protection order, and I want to make sure that it's going to be enforced in the state court. I want to, and if I'm hearing that it's not, what should I do?
Okay, so first, again, it's important to remember that as long as it meets the VAWA full faith and credit language, the state court is commanded by federal law to give it full faith and credit. But we also know that that's not always happening. One of the other things that is clear out of the VAWA statute is that you can take your order to another jurisdiction and have it enforced, and you don't have to register it. The reason for that was so that if you went to someplace else, let's say you escaped from your jurisdiction, went to another jurisdiction and filed your order and you registered it, the way the statute used to read, that court would then send a notice to your batterer that you just showed up in some small town someplace at their courthouse and filed your protection order, so they now know where you're at. So the statute now says that you cannot give that information out. If somebody registers it, unless the victim specifically asks in writing for it to be given to the perpetrator, to the person who is restrained, the court cannot give it to them. So what you may want to do, and again, it's not required, but if you want to be really safe, is go ahead into that other jurisdiction and register it with the court there. It then becomes an order of that court, and then it's enforceable throughout that jurisdiction. So if you're in Oklahoma and you move to go to a state court state courthouse and file it, then it's enforceable in all the state courts in Oklahoma. So if in fact there's a real concern about safety and real concern about it being enforced in state court, that would be my advice to you.
And what if, let me give you another hypothetical here. I'm in tribal court and I have a victim who needs enforcement of a state protection order. What would I be looking at in the tribal court at that state protection order?
Well, again, full faith and credit applies, so it should be enforcing it. Generally what's going to happen is there's basically two routes to the courthouse. One is because the police get involved, and the police should be enforcing it on the reservation, and either arresting or somehow informing the other authorities that there's this problem. So that's one way in which you could get into the courthouse. The other way is if you take your order to the courthouse and ask for it to be enforced under the tribe's law because there's been a violation. So again, what you need to find out is what are the penalties in your jurisdiction? Are they criminal? Is it criminal contempt, civil contempt? And that's going to make a difference because civil contempt has to be brought by the petitioner, whereas criminal contempt and the crime is generally going to be brought by the prosecutor for the tribe.
And so what if a non-Indian defendant violates a state protection order in Indian country and that tribe has not yet enacted the laws necessary to exercise special domestic violence criminal jurisdiction? What would happen then? Anything?
Sure, you could still use civil contempt or other civil kinds of remedies. So for instance, if you have a protection order and it's been violated, you don't have to file a civil contempt order necessarily. You could just go in and ask, and now we're talking about if you're going back to the issuing court. So if you go back to the issuing court and say, Judge, he's violated this order, I want the order modified to, instead of having no supervised visitation, I now want it to have supervised visitation. The court could reissue, modify and reissue the protection order with a no visitation clause in it now. So you could do it that way, or if it's not the issuing court, like you said, I think it was a state court that issued it, but you can still then, the petitioner could file and ask that it be enforced civilly if the violation occurred on the reservation.
One of the remedies that, oh, I'm sorry, go ahead, Virginia.
I just wanted to let you guys know we've got about 12 minutes left and several questions in the queue.
Okay, thank you.
Okay, so, and we've got one question from Brad Stinson. Brad, I'm not going to take your question first because I think we're going to have need some back and forth, so I wanted to give you a warning that I'm going to unmute you after this next question. But we have a question from Alyssa Harold asking, if support is ordered in tribal court against a non-Indian and they violate that order by non-payment, can you use civil remedies?
Yes. And civil contempt, assuming that he comes back to the court, assuming that he's found on the reservation or voluntarily comes back to court, what you could actually do is under civil contempt, if in fact he has the ability to pay but is not paying, he could actually be held in jail until he makes appropriate arrangements to either pay it or have it get paid. And there could be other civil remedies, again, that might be used against him.
And that's a civil remedy. I want to make sure that we distinguish that from criminal contempt and going to jail.
Yes.
And in some ways,
and again, we'll cover that next week.
Right.
Okay, should I go to the next question?
Sure.
Great. Okay, so Brad, I'm unmuting you, and I'm also going to read your question. Brad, is there a similar jurisdiction, protection order jurisdiction as compared to VAWA Section 904, or is the protection order jurisdiction based on the Montana test?
Well, there's...
Go ahead. Part of the reason I asked Brad was because I wasn't sure if he was talking about, you know, it kind of matters if the tribe is exercising special domestic violence criminal jurisdiction, is the person in question Indian or non-Indian, but go ahead.
No, can you explain what your question is a little bit?
Can you hear me?
Yeah.
Okay. The main problem that we see is we see people that live off the reservation want to come to the reservation and apply for a protection from abuse order. And I was primarily asking, is there an easy way to determine jurisdiction over those individuals? generally speaking, will have one tribal member involved and the other person involved will be a non-tribal member. And in my example, they would both live off the reservation.
And where did the act occur?
Well, what if the act occurred off the reservation, say at their residence?
Well, this is where I get into my wearing two hats, because I want to say that the tribe would have jurisdiction because you have a tribal member involved, but I think the federal courts would probably not approve of that analysis. I think they would probably say you don't have subject matter jurisdiction because it arose off the reservation, and neither party lived on the reservation. So it's likely that the mere fact that one of them is a member would not give the court sufficient jurisdiction.
With that being said, though, if I might, Judge Aycock, in Oklahoma, that scenario does present itself quite often in the tribal court. And again, it's because of the layout of what is determined to be Indian country and the tribe's service area there. And so I look to Seminole law, and Seminole law says that if the defendant has consented to the jurisdiction, and that can be by actions, that I can exercise civil jurisdiction. Let's just say that I've got some contacts with the defendant. I can show that he's in an intimate relationship with the tribal member. He's been to the Indian country before. Then I would start, because the tribal law allows me to do that even if the action occurs off of a piece of trust land, we might call it in Oklahoma, or restricted allotted land. I still could exercise jurisdiction there, I believe, if I set out the parameters of the Montana test. And again, it requires the tribal judge to be very careful about the evidence that's taken and the contacts with the tribe and the effect domestic violence has had on the tribe. So, and I would get something on the record there as well, that there has been, likely has been some sort of contact, either through social media, phone calls, third-party messaging, something like that, that has put this victim in fear. And I have to look at my tribal code and say, well, what's the purpose of the protection order here? What does a party have to demonstrate? And if that victim can demonstrate that to me, I'm just going to carefully draft the order, and I'm going to talk with the victim about, any jurisdictional issues that I think might arise or could arise.
Yeah, and my answer was based on the hypothesis that these people live and the act occurred clearly outside of Indian country or over any place where the tribe could assert some kind of authority. So let's say you're an Oklahoma tribe, but this occurred in New York City. Okay, and the person's never been to the reservation. The tribal member moved from Oklahoma to New York City, gets in a relationship, it's abusive. She now comes home and wants a restraining order. Now, here's what's interesting is there is some case law that says if in fact she came home because of the abuse and wants to be protected on the reservation, there's some case law that says that it would be okay for the court to grant that restraining order. It may not be adequate under full faith and credit, though. So if she went back to New York may not enforce it. Does that make sense?
That makes a lot of sense, and I think that's what I was trying to say, although you said it more clearly, is you want to sit down and make sure the victim understands. And usually tribal victim advocates are very good at this, although I have done it as well. In that situation, if the victim takes this order outside of Indian country, it could be challenged. Which kind of brings us back to the issue of, well, then does the victim get one in tribal court and then go get one in the state court as well? if the state is not enforcing the tribe's protection orders, and the tribe's protection orders comply with VAWA full faith and credit. And Virginia, I think you had mentioned a letter that the Attorney General that had been sent to the state of Alaska by was it the Department of Justice?
Yeah. Yeah, I mean, the state of Alaska was kind of notoriously refusing to recognize tribal court protection orders, and and that just violates federal law. So the Department of Justice sent a letter to the state telling them, reminding them of their obligations, and and intervening in an effort to get them to comply. That has been, I think, has been successful. The state, I'm sure that there are still challenges, but the state has responded positively to the Department of Justice's pressure to get them to recognize tribal court protection orders.
And I see the enforcement mechanisms sometimes playing out with the children, and that's why I think it was so important that Judge Aycock underscored the importance of naming those children in the protection order, so that if the custody or visitation arrangements have been violated within the text of the protection order, that you you have a better chance of getting those enforced across jurisdictional boundaries.
And I think it's important also, talking about the children, that if you're working with a victim who already has a protection order but is pregnant, that once the baby is born, that she immediately asks the court to modify the order to also cover the baby. Do we have any other questions?
Yeah, I hear typing, and we have a little bit of background noise, so I don't know.
Yeah, I made sure all of our attendees are back on mute, and we've got one more question that's been written in. I'll read that now, from Janet Jessup. One source of friction for the tribes and state in my area is that tribal protection orders are not enforced in state courts. The reason cited by state judges has been the lack of notice to the accused batterer. It's understood that most tribes don't have the resources for process servers or dedicated law enforcement. Any recommendations for tactfully addressing this challenge with state and tribal partners? Note, none of the tribes involved have implemented TLOA or VAWA.
Yeah, I mean, I think one of the things that the tribe and the state could do is there some way that you could get the sheriff to help do service off the reservation? I'm assuming the problem is serving people off the reservation, because if it's on the reservation, your police ought to be able to do that if you have police. If not, it sounds like somebody ought to start up a little business on the reservation of serving papers, because they can get paid for doing that, although you can't charge the petitioner for it. So, so that one way would be is to reach some sort of agreement with the state where they would help do the service off the reservation. The other thing then is that if it's an ex parte, so the party has not got notice, as long as they're going to get notice and an opportunity to be heard within a certain amount of time, then that's reasonable, then it's still enforceable under VAWA full faith and credit.
I know this topic has come up several times in several conferences where I've been at, and some tribes have traditional means of providing notice. Now, we're not talking about the opportunity to be heard, because clearly that means that the defendant has an opportunity to stand in front of the tribunal and tell their side of the story. But notice, I think, can look different from tribe to tribe, as long as the tribe and its tribal code has written down what they have found to be due process, what is fair notice. And I can just remember one of the tribes talking about, they don't have a process server. It's a very, very, very tiny tribe, and the way they get word out to people might be the announcement, the village announcements, or something of that nature. So, I mean, it's just hard to say yes or no, because I think a carefully worded tribal code that incorporates custom and tradition with respect to notice might not have to look exactly like it does outside of Indian country. Although, you know, the purpose has to be to make sure that the batterer indeed knows that there's something going on, you know, an action filed, gets a copy of the filing, and has an opportunity to come into court and tell their side of the story.
But let's also remember, in a civil case, if the person is basically hiding from service, or because of just lack of resources, people can't be served, the other opportunity is notice by publication. So you can ask the court to allow notice by publication. You'd have to publish it in a newspaper that's likely going to cover where he's living. That would also then say something about what the case is about and what he's what you're asking for relief, and then a date, a court date. But just the normal notice by publication. People get judgments all the time by notice by publication, and there should not be a problem if that's how service got rendered.
And we might want to have a conversation about victim safety and protecting the victim's name and those sorts of things, but I certainly agree. If the tribal code allows that, yes.
Are there any more questions? I've gone through all the questions that were in the queue.
The last questioner. So my email is Stephen with a V _ Aycock, AYCOCK at ncjfcj.org. And actually, this applies to any of you. If you want to get a hold of me and have further questions or want to follow up on anything we said today, please contact me. And my phone number is 775-507-4802.
So I'll go ahead and give my contact information as well. It's Kelly, K-E-L-L-Y, at TLPI, that stands for Tribal Law Policy Institute.org, and my cell number is 405-226-2050, and I'm happy to help if I can be helpful. With that, Chia, Virginia, I think we'll turn it back over to you if we have no more questions.
Okay, thank you everyone for attending, and we will have another webinar, the last in the series, next Tuesday at the same time. And I will go ahead and email out the slides and a link to the recording once it's available, so expect that within the next 24 hours. And again, thank you all for attending, and thank you, Steve, Kelly, and Virginia. And everybody have a nice day.
And Chia, can you put our contact information in the email when you send it out?
Yes, I will do that.
Thank you.
Thank you. Bye, everybody.
Thanks, everyone.
Everybody. Bye-bye.